Okay, so in this PowerPoint, we're going to look at real property problems and explanations for units 23 and 24 in your text. We will first look at problems for unit 23, which is real property, interest, and rights. And these are the problems that we have in estates and land, future interest, concurrent estates, rights incident to possession and ownership, non-possessory interest in land, and land use controls. So problem 4 is looking at estates and land, and it's talking specifically about a life tenant. And a life tenant is entitled to reasonable use of the land. And a life tenant may not exploit the natural resources, but if the land was so used at the time the life tenancy was granted, the grantor is deemed to have intended continued reasonable use. So if we look at the problem, it says a life estate is the right of a person to use property for the rest of his or her life. This person is a life tenant. Certain duties and limitations are imposed on the life tenant to safeguard the remainder man's rights. The remainder man is the individual who gets the land at the end of the life tenant's life, or when the life tenant dies. So answer A is incorrect because the life tenant is entitled to the profits from the land so long as waste is not committed. And answer B is incorrect because the life tenant is responsible to pay ordinary taxes on the land, but not those constituting assessments for permanent improvements. And then answer D is incorrect. The life tenant is only responsible to maintain the land and structures on it in a reasonable state of repair. So reasonable depreciation is allowed. So answer C is the correct answer because they may exploit the natural resources if the land was so used when the life estate was granted. So for example, if the life tenant receives the land and it's a Christmas tree farm and they continue to use it as a Christmas tree farm, selling off trees each year and replanting trees as a replacement, that would be considered a reasonable use. Okay, so problem 6 is looking at future interest, and it deals with the rule against perpetuities. And the rule against perpetuity states that a future interest must vest or fail to vest within 21 years of after a life in being. So specifically what they're saying is that any life in being that is a party to the transaction, the future interest must vest or fail to vest within 21 years after their life has ended. So in this case, in year 11, Alan and Tony entered into a contract with Mark in which they agreed to sell Blackacre to Mark in fee simple. After examining title, Mark refused to perform on the grounds that Alan and Tony could not give good title. Alan and Tony joined in an action against Mark for specific performance, and the question is asking whether or not specific performance will be granted. You have to go back up to the top of the page. So in year 1, Ray Rogers, owner of both Blackacre and Whiteacre, executed and delivered 2 separate deeds by which he conveyed the 2 tracts of land as follows. Blackacre was conveyed to Alan and his heirs as long as it is used exclusively for residential purposes, but if it is ever used for other than residential purposes, then to the American Heart Association. Now the question, number 6, is dealing with Blackacre, so we're not necessarily going to talk about Whiteacre. So Ray Rogers, the grantor, died in year 6, leaving a valid will by which she devised all of her interest in real estate to her brother John. The will had no residuary clause, and Rogers was survived by John and her son Tony, who received the balance of her estate. So when we look at the rule against perpetuities, you have to determine if a life in being, so Ray Rogers granted it to Alan, and would that future interest vest in Ray Rogers or Alan within 21 years after their life ended. Now, she died in year 6, so 21 years plus 6 would be 27. Alan is still currently alive and he's trying to sell it, but the point is there's no possibility that they can guarantee that the interest will vest within 21 years after life in being. So for example, let's say Alan kept the property for 50 years and then he sold it to a developer, and so it was not going to be used for residential purposes anymore. So that would be beyond 21 years of a life in being. Or let's say that Alan died, it went to his children, they used it for residential purposes. but it would not vest or possibly vest within 21 years after their life, because we have no idea of when their life would end. So it either has to vest or fail to vest within 21 years after life and being. So the idea is that this grant to the American Heart Association was void because it was against the rule against perpetuities. Thus, Allen had a fee simple determinable for his life with the possibility of reverter to Ray Rogers and her heirs. So because the grant to the American Heart Association was void at the end of Allen's life, or at the end of Allen's life, the property would revert to Ray or her heirs. And in this case, in her will, she left her real estate to her brother John. So John holds an interest and Allen holds a life interest. However, Toni does not hold an interest because she did not will her property to Toni, but rather to her brother John. So if you recall in question 6, Allen and Toni entered into the contract and Toni doesn't have a valid right. So answer A is incorrect because Allen and John together own a fee simple absolute in Blackacre. So that means that they together own a fee simple absolute. Allen's is a fee simple determinable for his life, and then it reverts to John, Ray Rogers' heir, for fee simple absolute. Answer B is incorrect because Allen owns the fee simple determinal, which may be divested whenever it is used for purposes other than residential. So during Allen's lifetime, if he uses it for some other purpose other than residential, then it automatically reverts to John. At the end of Allen's life, even if he was using it for residential purposes, he can't send the property to or give the property to his heirs or to his estate. It automatically reverts to John because it doesn't matter how he's using the property or how his heirs would use the property. It automatically reverts to John, and the American Heart Association is out of the picture. And answer D is incorrect because, as I said, the American Heart Association has no interest in Blackacre. The rule against perpetuities invalidated its executory interest that Rogers tried to convey. So answer C is correct. It's denied because John has a valid interest in Blackacre and John is not a party to this real estate contract. Okay, problem 10 is dealing with concurrent interests. Joint tenancy is a form of co-ownership in which each tenant owns an undivided interest in the entire estate. So if you have a 100-acre estate and there are two joint tenants, there's no way to separate and divide that. You can't say that person A owns 50 acres and person B owns the different 50 acres. They literally own every piece of that land together or jointly. So there are 4 elements or unities that must exist to create a joint tenancy. The element of time, the interest must vest at the same time. The element of title, the interest must vest under the same instrument, such as a deed. Interest, the interest must be of the same type and duration. And the element of possession, the interest must represent identical rights of enjoyment. Now the question is asking you which of the following unities or elements are required to establish a joint tenancy. So the answer is A is correct. It's the only one that shows yes to time, title, interest, and possession. Okay, problem 13 is also dealing with concurrent estates. And the question is asking a person may own property as a joint tenant with the right of survivorship with any of the following except. And so how a joint tenancy works is that the two own it jointly and it can never be severed. But when one of them dies, then the other joint tenant owns it in full. So if there are 2 tenants, tenant A and tenant B, tenant A cannot will their portion of the estate to someone else. The estate upon tenant A's death automatically goes to tenant B. Doesn't matter if there's a will or there's a state law regarding the passage of property. So because the right of survivorship is in a person, a corporation is granted perpetual life. So most states do not allow most states that allow joint tenancies, they do not allow them to be created in a corporation because the corporations are granted perpetual life. Thus the right of survivorship would be meaningless to the other tenant. So since a corporation never dies, there are other situations that make a corporation go out of existence, but it is granted perpetual life until one of these other situations occur. So they're not allowed joint tenancy because then the other person would never be able to have the right of survivorship and take ownership of the property. So A is a divorced spouse, B is a related minor child, and D are unrelated adults. So all of them are able to have a joint tenancy, but an unaffiliated corporation, answer C, is incorrect. Problem 15 is also dealing with concurrent estates, and the question is, in 1990, Harold bought a house from Sydney. In 1992, Harold married Wilma, and they have lived continuously in the house together since then. Bart is now negotiating with Harold for the purchase of the house. Which of the following is true? So we must first understand what the laws are with regard to husband and wives or spouses. At common law, a wife and or husband gained rights, which was a life estate, in their spouse's property during marriage. Most states now by statute create that right in each spouse, and a life estate exists even when there is an innocent purchaser. So if we're looking at those rules, answer A is incorrect because the wife interest is not one of adverse possession. Wilma's use of their residence is clearly permissive. Answer C is incorrect because a wife's interest may prevent conveyance solely by a husband. And answer D is incorrect because the community property system, which is followed in California and a minority of other states, recognizes that the husband and wife should share equally in property acquired by their joint efforts during marriage. It imparts no special interest to children, however. So the answer B is correct. Bart should have Wilma sign the deed because she may have rights in this property by virtue of her status as a spouse. If you can remember in the narrated PowerPoint, we talked about a quitclaim deed, and she could sign something to that effect, or she could sign the actual deed between Bart and Harold and just be a party to that deed. Problem 19 is dealing with rights incident to possession and ownership, and it's specifically talking about adverse possession. Dunbar Dairy Farms, Inc., pursuant to an expansion of its operations in Tuberville, purchased from Moncrief a 40-acre farm strategically located in the general area in which Dunbar wishes to expand. Unknown to Dunbar, Lamont Cranston, an adjoining landowner, had fenced off approximately 5 acres of the land in question. Lamont Cranston installed a well, constructed a storage shed and garage on the fenced-off land, and continuously farmed and occupied the 5 acres for approximately 22 years prior to Dunbar's purchase. Cranston did this under the mistaken belief that the 5 acres of land belonged to him, and they're asking which of the following is a true statement. So title to real property may be acquired by adverse possession if the following requirements are met, and all of these requirements are needed. Actual and exclusive possession of a land, and this appears that Cranston did have actual and exclusive possession. Possession must be open and notorious, so he was openly occupying the land. He built a fence, a pond, a storage shed. Possession must be adverse to the rights of the owner, so they can't be sharing it equally. So in this case, it would be adverse to the rights of the owner because Dunbar Dairy Farms, because Moncrief is not occupying the land at the same time. And possession must continue uninterrupted for the full statutory term, which may be as long as 20 years. So adverse possession runs on different years in different states, but the maximum of any state is 20 years. And in this case, they stated that he occupied it for 22 years continuously. And the possession must be peaceable. And what they mean by that is that Cranston couldn't have taken the property by force or any type of illegal activity in which he gained ownership or gained possession of the property. So which of the following statement is a true statement? Answer B is incorrect because adverse possession will prevail against a properly recorded deed. And answer C is incorrect because Cranston can obtain title to the property by way of adverse possession. And answer D is incorrect. As a purchaser of real property, Dunbar is considered to have constructive notice of Cranston's presence, and Cranston has acquired title by adverse possession, has nothing to record, and cannot be ousted as a trespasser. Because he gained title through adverse possession, he is not considered a trespasser. Now, if this was in year 2 or 3 and this sale was going on, then Cranston would be considered a trespasser and would be required to remove or return the property to Moncrief. So answer A is correct. Under the circumstances, Cranston has title to the 5 acres. Okay, problem 24 is also dealing with rights incident to possession and ownership. And in this case, Old MacDonald owns a small farm located on the edge of a small creek that he uses for irrigation. Grub Inc. has purchased the land just upstream from MacDonald and is building a 20-story condominium project. In the construction, the creek was blocked and detoured to another creek bed 1 mile away. The building will also cut off the sunlight needed to grow crops on MacDonald's land. Which of the following rights does MacDonald have? So the question, if someone owns property that's adjacent to and is part of or on the edge of a waterway, it could be a creek, lake, water, ocean, they're considered a riparian landowner, and a riparian landowner may make reasonable use of the water, and a lower riparian owner has the right to continued flow of the water without unreasonable diminution. So in this case, Old MacDonald is a lower riparian owner, and reasonable use theory allows use of the water as long as it does not interfere with other riparian owners. And in case this situation talks about what rights does MacDonald have. So answer B is the right to sunlight in order to grow crops. This is incorrect. There is no general right to have direct sunlight on one's own property. Answer C is the right to be free from the construction dust and later from automobile exhaust. That's incorrect. There is no right to be free of air contaminants, although excessive air contamination could constitute a private nuisance, which is a different type of suit. And answer D, the right to the magnificent mountain view that previously existed from MacDonald's farm. And that is incorrect because there's no general right to retain a view recognized absent an express agreement. So answer A is the correct answer, the right to have the water continue to flow in its natural course. So if MacDonald were to sue, the court would most likely require that the creek be put back to its natural waterway and be directed down to MacDonald's property. Problem 29 is dealing with an easement by necessity or a non-possessory interest in land. So non-possessory interest in land, an easement by necessity is recognized if the parcel would otherwise be landlocked and access by a difficult, circuitous, or otherwise inconvenient route defeats the easement by necessity. So it truly has to be by necessity, not by convenience. So the question asks, an easement by necessity is recognized when A, a parcel of realty is conveyed that is inaccessible or accessible only by a difficult route, and that is incorrect. B, a grantee but not a grantor is left with a difficult access to realty as a result of a conveyance, and that is incorrect. C, a landlocked parcel of realty is conveyed, and that is the correct answer. Answer D is incorrect because a grantor but not a grantee is left with a difficult access to realty as a result of a conveyance. So if difficulty is involved, that's clearly not the issue. It has to be by necessity. So only A, a landlocked parcel of realty is conveyed. Problem 35 is dealing with land use control. The Civil Rights Act of 1968 is commonly known as the Federal Fair Housing Act, and the act makes illegal the refusal to rent to someone because of, and the answers are marital status, disability, age, or country of origin. And the Civil Rights Act of 1968 made it illegal to refuse to sell, to rent, or to negotiate housing issues based on a person's race, color, religion, national origin, or sex. So the correct answer is D, country of origin. The other three are not what we call protected classes in the Civil Rights Act of 1968. Problem 44 is also dealing with land use controls, and the question states, a court rules that city government regulations are overly restrictive of Mary's use of her land. The city government must. And when we're talking about land use controls, public control of land use falls under two categories, eminent domain and police power. An eminent domain is the power of government to take land from private owners through condemnation when the taking is for a public purpose and the private owner is reasonably compensated. Police power is the broad power of state and local governments to promote the public health, safety, and welfare, for example, through land use regulation, such as zoning. Under the police power, land is not appropriated by the government and compensation is not paid to the owner. Regulations that are so restrictive that the owner is deprived of all of the land affect a taking, and the government must pay reasonable compensation under the eminent domain concept. So if we look at these four answers, B says condemn the land under its police power and provide Mary with an equivalent parcel of land elsewhere. And that is incorrect because condemnation is based on the power of eminent domain, not police power. Answer C, states file a comprehensive plan with the court as a basis for seizing Mary's land. And that's incorrect because a comprehensive plan is a set of standards that forms the basis of a zoning code. It is not necessarily a specific document. It's not filed with the court, although a court can use it to evaluate the propriety of a zoning and administration's actions. A comprehensive plan is not a basis for seizing property. And D is incorrect. The attempt to bargain with Mary to purchase a property because the court has ruled against the city. The court's unfavorable ruling does not prevent the city from pursuing condemnation of the property. So answer A is the only correct answer. Condemn the land under its power of eminent domain and pay Mary reasonable compensation. So next we're going to look at the problems in Unit 24, and we'll look specifically at the sections of real estate contracts, conveyances, recording, and fixture with real estate contracts, and they must satisfy all requirements of a valid contract. So there must be an offer and acceptance, consideration, legality, and competent parties, and the contract to sell must also be in writing and signed by the party to be bound. So the question asks a contract for the sale and purchase of real estate, which is called the real estate binder. Answer B is incorrect because it says does not transfer risk of loss to the buyer until the closing unless the parties expressly agree otherwise. The majority rule is that risk of loss passes to the buyer upon formation of the contract, but contracts for sale of real property frequently make other arrangements. Answer C says transfers title but not possession, and that's incorrect because the transfer of title by deed commonly occurs at the closing. And answer D is incorrect, is not effective unless recorded. The contract is effective between the parties when formed. Recording puts third parties on notice of the existence of the contract. So answer A is correct, must satisfy the general requirements applicable to all contracts as well as the statute of frauds. Problem 6 also deals with real estate contract, and the question states which of the following remedies is more likely to be available for a breach of contract to sell real estate rather than personal property. And the equitable remedy of specific performance will be granted when the legal remedy of damages is insufficient. For example, because the subject matter is unique and all property is considered unique. So contracts to sell real estate are specifically enforceable. And while contracts for the sale of antiques and other rare items are also specifically enforceable, most contracts concerning personal property are not. So answer A is incorrect. The non-breaching party may, if the breach is material, elect to rescind and not be bound by the contract. So this remedy is customarily available for personal property and not real property. Answer C, damages, is incorrect. That's a typical remedy for breach of a contract involving personal property. And answer D is incorrect because replevin is an action to recover personal property that was taken unlawfully. So the correct answer is answer B. Problem 12 deals with the issue of conveyance. A majority of states and real estate deeds require the signature of the grantor, notarization and or witness of the signatures, and names of both the grantor and the grantee. So the question asks, in the majority of states, a deed must be signed by A, the grantor and grantee but not witnessed or acknowledged, and that's incorrect. B, the grantor and grantee and acknowledged, and that's incorrect. C, the grantor but not the grantee, and that is correct in the majority of the states. And D is incorrect, the grantor and the grantee and both witnessed and acknowledged. Problem 14 also deals with the issue of conveyance, and the question states Ned executed a deed naming his son John as grantee. John paid no consideration. The deed described the property as follows: all of my land and dwelling known as 72 Back Road, Crosstown, United States, being 1 acre. The property at 72 Back Road actually covered 7/8 of an acre of land, and the description of 72 Back Road was, and the question is asking. And so an effective conveyance requires a legally sufficient description of the property. If you can reasonably determine what he was trying to sell in the legal description, then it suffices. It doesn't have to be exact. So in this case, since he said 72 Back Road, all of my land and property dwelling known as 72 Back Road, that is considered reasonable sufficiency. So answer A is correct, sufficient because the discrepancy in the area is not fatal. So if he said 72 Back Road and he actually owned 72 Back Road and 78 Back Road, and he was trying to convey 78 Back Road, then that legal description would be insufficient. As long as there's no confusion, and in this case he clearly lists the address of where it is, the issue of 1/8 of an acre is not sufficient enough to void the contract or the real estate agreement. Problem 22 is dealing with conveyances as well, and it's specifically talking about the new home warranty, which provides a warranty against defects in workmanship in most states. The question is asking, Joe and Minnie Sixpacks just purchased a new house from the contractor who built it. Under the law in their state, the seller of a new house is required to provide a warranty for at least 1 year against defects in workmanship. Under the typical statute, which of the following is covered by the warranty? B talks about a mechanic's lien for work performed on the house by a subcontractor who is not paid by the contractor, and that's not a defect in workmanship, so it would not be covered. Installation of fixtures in the bathrooms different from those agreed upon. And this is an issue, but it's an issue of a breach of contract, that they contracted to supply these types of fixtures, and in fact they supplied a different one, so it's not a breach of workmanship. Construction of a sidewalk by the city between the house and the road when the Sixpacks thought that they had all right to the land up to the road. And this is a question regarding an easement, and so they would need to take that up with the seller and with the city. It's not a defective workmanship. So answer A is correct. A serious crack in the foundation is a defect in workmanship, and that would be covered by the warranty. Problem 27 is dealing with the issue of recording. Miss Bean deeded her home to Park on July 1. The deed was never recorded. On July 5th, Bean deeded the same home to Charles Knoll. On July 9th, Knoll executed a deed conveying his title to the same home to Baxter. On July 10th, Knoll and Baxter duly executed their respective deeds. If Knoll and Baxter are bona fide purchasers for value, which of the following statements is true? So there are 3 kinds of recording statutes: a notice statute, a race notice statute, or a race statute. In the notice statute, an unrecorded deed is ineffective against a subsequent bona fide purchaser for value and without notice. And in this case, they were states that they were bona fide purchases for value, and they did not have notice because the deed was not recorded. Under a race notice statute, the subsequent bona fide purchaser must record before the prior grantee. Under a race statute, regardless of notice, the first to record prevails. Because Knoll and Baxter were bona fide purchasers who recorded before Park, they would prevail in every state. So B states Bean's deed to Park was void as between Bean and Park because it was not recorded, and that is incorrect. B, recording has no effect on the right of the parties to the conveyance against each other. And C is incorrect. Bean's deed to Knoll was void because she had no interest to convey. And it's incorrect. Before Park records, Bean has the power to make an effective conveyance to a subsequent bona fide purchaser who complies with the recording statute. And answer D, Baxter can recover the purchase price from Knoll. Knoll and Baxter are protected by recording, so Baxter has a title superior to Park's and no basis for recovery against Knoll. So answer A is correct. Baxter's interest is superior to Park's because he recorded and he was a bona fide purchaser for value. Problem 30 is also dealing with recording, and it talks about a purchaser obtains real estate title insurance, what rights that they gain. And title insurance policies insure against all defects except those noted in the policy. So there might be possible exceptions, but they have to be specifically stated in the policy, and all title insurance policies are required to be written. So answer A is incorrect. Title insurance for the benefit of an owner usually covers the purchase price, but a policy written to protect a mortgagee may be for the amount of the mortgage. Answer C is incorrect. Title insurance indemnifies from title defects that result from events that occur prior to the effective date of the policy. And answer D is incorrect. Title insurance is not assigned to a subsequent buyer. A new title examination is necessary before such a buyer can receive title insurance. So a title insurance policy cannot be transferred. So therefore answer B is correct. The title insurance will be insured. The purchaser who obtains title insurance will be insured against all defects of record other than those accepted in the policy. Problem 32 is dealing with fixtures, which we talked about in secure transactions and a little bit in the PowerPoint. And so the question is asking, a tenant's personal property will become a fixture and belong to the landlord if its removal would. And so you have to look first at the intent of the parties, and that's what controls in determining whether a tenant's personal property becomes a fixture and belongs to the landlord. In the absence of an explicit statement, you have to consider the mode of annexation, damage to the real property and the item if it is removed, and the degree to which the item is specifically adapted to the realty. So answer A says if the removal would increase the value of the personal property. Whether removal will increase the value of the personal property is not a significant consideration compared with damage to the real property. Answer B says cause a material change to the personal property. And that is incorrect. Whether removal will cause a material change to the personal property is not a significant consideration compared to the damage to the real property. And answer D, change the use of the landlord's property back to its prior use. Whether removal will change the use of the landlord's property back to its prior use is not a significant consideration compared with damage to the real property. So answer C is correct. A tenant's personal property will become a fixture and belong to the landlord if its removal would result in substantial harm to the landlord's property.